बेसिचेर ते प्रोटेस्टाक I was one of the member of the team. A week back आमकां ते गॉडफ्रीन फोन करून म्हाका सांगलेलो आपण म्हणलेलो MITची प्रोटेस्ट मिटींग आपण करता आपणाच्या सायटीर. हांवें सांगलें बाबा रे म्हणलें ते सायटीर मिटींग कित्याक करता तूं ती मिटींग म्हणलें थिंगासर डिस्प्युटेड लँड आहा आनी इट इज नॉट करेक्ट टू होल्ड अ मिटींग ओवर देर बिकॉज द एंटायर 6,000 lakh square meter is belong to the comunidad and the 2 lakh belong to the MIT. So trespassing and all these things will be dispute land will not be correct. Better we sit across the table because this decision was taken by him and his colleague Hateni, but myself and Molly were not there and we have not joined nala sir. So I said Baba you better postpone that meeting because Molly will be having her exam and I don't think because unless we follow the procedure आम्ही ती मिटींग करप सारकें न्हू तर तो आपण हे येवपाचे आहात ते येवपाचे आहात व्हडले व्हडले येवपाचे आहात हांवें सांगलें ते कोणूय येवं न्ही पूण इट इज नॉट रायट थिंग बिकॉज आमी बसया चेकआउट द प्रोग्राम आनी आमी ती मिटींग घेवया म्हण सांगलें आनी तेणें आमचें नांव एड केलें भितर आनी तेणें तो प्रोग्राम सर्क्युलेट केलो आमी ताका सांगलें बाबा मिटींग हांव चड करून पावचो ना कित्याक मोली पावचें ना हांवूय पावचो ना आनी अनफॉर्च्युनेटली म्हाका कितें जालें म्हाजें कजन वॉज सीक आनी आय हॅड टू रश टू मारगांव टू कोलवा आनी आय वॉज नॉट देर फॉर द मिटींग दॅट इज द वॉट इज द वाय आय डीड नॉट अटेंड द मिटींग.
बट तुवें जेन्ना ताका सांगलेलें पळय पावचो ना म्हणून तरी तुमचें नांव मॅसेजीन
सर्क्युलेट जातालें पूण तो आतां घालता जाल्यार आनी तोच घालता जाल्यार ताका जबाबदारी हांव घेवचो ना न्हू ताका ही इज आन्सरेबल फॉर दॅट कित्याक हांवें ताका सांगलां मिटींग कितें घेवपाक पयलीं आमी बसया डिस्कस करया प्रोसिजर फॉलो करया कित्याक तुका जर सांगतले डिस्प्युटेड लँड आसता थंयसर कितें आसता लँड ओनराची NOC जाय पडटा पुलिसाचो परमिशन घेवचें पडटा जायते फॉर्मेलिटी करचे सो दॅट वी हॅव टू थिंक ऑफ आनी बरोबर करया आतां जाता कितें जाणा तो ही इज यंग आमी हांव मोली 70+ आनी तो कितें आहा ही इज 50 अरावंड आनी ताका यंग ब्लड आहा ही वॉन्ट टू आपणाचें एन्थुजियाझम कितें करूंक सोदता जाल्यार ताका करूं न्ही बिकॉज द गोल इज सेम दॅट वी आर प्रोटेस्टींग एगेन्स्ट द युनिवर्सिटी दॅट इज अ प्रोटेक्ट आवर विलेज दॅट्स अ होल थिंग आमी वचोंक तुका सांगणें म्हणजे कितें हांव वचोंक ना म्हणजे कितें आसा म्हाका तें दिसलें की इट वील नॉट बी रायट विदावट फॉलोईंग द प्रोसिजर ती मिटींग थिंगासर वचप म्हणजे अननेसेसरी फाल्यां कितें तरी अनवॉन्टेड इन्सिडेंट जालो जाल्यार वील बी टार्गेटेड आनी वील बी आन्सरेबल एनीवेर सो दॅट वॉज द रिजन आय डीड नॉट अटेंड द मिटींग.
What is the status of this?
That will second.
My name is Molly Dogama Silva, and I'm the villager of Thivi. I live in Kansa. That also where the MIT University is coming up in one of the parts of Kansa. At when we were informed that the MIT was coming up, Robert and myself, we contacted Advocate Carlos. And from that day, Advocate Carlos has been helping us. He's been very kind. He went to all the departments to get the papers to different, with great difficulty, he managed to get all the documents together and he submitted them in the Bombay High Court. He was very aggressive in the Bombay High Court, but you know how it is, what the judiciary system and how it works in India. But Advocate Carlos has been with us throughout. The only thing is, yesterday we could not attend a meeting because I had my board exams, and after that I had to attend the funeral of my uncle. So it was just not possible, and 2 weeks back I had requested Godfrey to kindly postpone the meeting since we had this board exams going on. And even the previous day, 2 days before, he said, okay, maybe yes, no. Then Robert too requested him to postpone the meeting. Even though I was not there yesterday, by spirit I was present on the hill because I knew that there was a protest going to save our village land. First of all, we are so worried what is going to happen when it rains. The flood assessment is not given. Advocate Carlos has asked even for the hydrological data and all the project reports in fine details, and we know the democratic shift is going to take place of this land. We are going to be affected very badly. There's going to be floods pouring down now when the monsoon starts. Sogli poi mati poi voir kadल्या दोंगर कातोला सगलो ती सगली माती सोकला धांवन येतली. कितें करतलो आमचो लोक त्या वक्तार? तेन्ना तें चिंतप ना थोड्या लोकांक कोम्युनिटीच्या लोकांक कांयच चिंतप ना ते काडून दिली तांकां ₹1 12 पैसा एक स्क्वेअर मिटराक कितें फायदो जालो वी आर द वन्स हू आर एक्चुअली गोइंग टू सफर इन cancer. This is what, and I really thank the people and all the activists who came yesterday to support our cause. Even Godfrey, okay, he's gone ahead and done it. It's a great effort by Godfrey too. And our special thanks to Advocate Carlos because right now he has been processing all the papers, helping us, getting all the documents to go to the Supreme Court. Advocate Ishan George is in touch with us. And of course, he could not get in the matter in the Supreme Court because he had a problem in the house. There was a death in his family. And he's brushing up the matter for the Supreme Court. And the Gaunkars are all with us, and they are going to sign the petition for the Supreme Court. So this is all what really we have a lot to say about this. And I think I would request Advocate Carlos to talk on the matter next.
First and foremost, you already heard from Robert and Molly about why they were not present at the meeting yesterday. But there is one statement which was made by Godfrey which I don't think was in proper or good taste, where he claims that after the judgment came against us, that for 4 months I've disappeared. First thing, I think Godfrey should have told that from the beginning I have been helping, not only getting the documents. Personally, I went department to make sure I got things. Even the incomplete documents which were submitted, I said that's not enough, and I got other documents. Finally, we filed a petition, we argued it. It's a different matter that the judgment came against us, but I don't believe that's the end of the matter. Because I felt that the judgment is not right, I advised them go in appeal, and I gave them an advocate on record who files a matter in the Supreme Court. In the Supreme Court, it's not I who file it, nor anyone from Goa who can just file it. You have to be an advocate on record. So it's an advocate on record to whom I gave. Unfortunately, he himself had a surgery first, and after that, I think his mother died, yes. And that is why he was not in a position to prepare that SLP. Anyway, I'm told that he has already sent the draft to the SLP sometime before this meeting took place, yes, to Molly.
Yesterday.
And the documents and all that. And they will sign it and they will send it back. It should be realized that I'm a senior advocate. I'm not a junior advocate. So in a senior advocate, the responsibilities are different. And we take a brief, we have a advocate on record, and we argue the matters. It's not like that we are drafting, we are doing everything. So I have gone overboard in this matter and not charged ₹1 in this matter, which otherwise, I would have charged good fees in matters which I appear. But I have not charged because I have a belief. First belief I have is that the setting up of this MIT here, the entry of MIT here is a fraud. They got a letter of intent which I have argued was fraudulent. I want to make that point also, make it good in the Supreme Court. Because before you had the land, you got a letter of intent. Because the law at that time was you had to own the land. And that has been held in their favor. That is surprising. Second part of it was, this is not a scheme of the government of Goa to grant Comunidad lands. Because according to me, you are giving Comunidad lands which is at least 2 lakh square meters, which can be given on the basis of a scheme. And the court said that the provisions of the Private Universities Act is a scheme. It can't be so. We will have that thrashed in the Supreme Court whether it's a scheme or it can be accepted or not. Thirdly, the land was being given at a throwaway price of ₹12.50 per square meter, not ₹1 12.50. It is ₹12.50 a square meter, which is a throwaway price. And I pointed out that in the High Court, that this institution is not a charity or charitable institution. It is an institution which will charge fees, it will collect fees from NRIs and foreign students in lakhs of rupees. And it's not that they don't have the money or the resources. And if they don't have, because they have said they're going to spend 350 crores plus before IPB. So if they're going to spend so much money, they have money even for the land. So why should they be given, virtually be gifted the land? and that of the comunidad at the detriment of the comunidad. Of course, they tried to show that they had made some agreement with the comunidad where they are going to give some jobs and they are going to give some admission to the gaunkars and all these kind of things. But all that detail, the fine detail, was not in the minutes of the meeting, and suddenly it was sort of be inserted in the lease deed. So all that was shown to the court, but still the court ruled that in their favor, and that is why we are constrained to proceed in appeal, and the appeal will be filed. I think there's a miscommunication between Godfrey and me, because Godfrey, I remember speaking to me once, and I remember I was in some function. I don't have his number saved on my mobile, otherwise I would have called him back. And he called me and I said, I am actually busy, because when you are in a function, I don't take a call. But if I have the number of the person, I call back. So, and I could not talk, and definitely therefore I could not give him any proper answer at that time. So I think Godfrey could have called me back and got the response, instead of saying that after 4 months I disappeared. He tries to say this, giving as if like a very bad impression that I disappeared, that I don't do this kind of things. And I still believe that this judgment will be a test judgment, in the sense it will set a wrong precedent in the grant of lands of comunidades for these institutional purposes. And I think we need to get this correct, because lot of such kind of universities are coming and applying for comunidad lands, and the comunidad lands are virtually being frittered away, and this will be another precedent which they can use, and they will be able to just allow comunidad lands to be given at a throwaway price or at a song. So this is what I wanted to make this clear. And of course he expresses his concern and says he doesn't know why the other members like Molly and Robert had not come, but now you heard the reasons what they have spoken of, and I think that should put the controversy at rest. It was a storm over a teacup, how you say that,
Yes,
and
brewed up over a teacup.
yeah, so therefore I think we should not read too much into this, and I think it's just simply a misunderstanding, and he could have got these things right, because we have one common goal. We need to save the comunidad lands from destruction. We need to save comunidad lands from these crony capitalists who want to grab the land and deprive the gaunkars of the land. I'm in favor of lands going to in hands of the gaunkars. I'm in favor of things being done in the interest of the gaunkar. But when it's being done for such commercial entities, then I don't think I'm in favor of it, and I think the comunidad gaunkars majority would stand with me on this point.
अपडेट कितें आसा आतां तेचेर?
आता appeal तांकां draft धाडला. Once they print this, they will swear the affidavits and they will sign, and I think within a week or maybe 10 days they will have that appeal filed in the Supreme Court. In 2024, January or February, they got the letter of intent, and the lease is executed in July of 2024. You understand? So how could you get a letter of intent? Because even under the amended law, it should have been leased to you. So without the lease, how you got it? So if that was struck, your entire basis of starting that process would have been knocked off. Second part is about these grants, because they made an amendment in 2001 to the Code of Comunidades to allow 2 lakh square meters to be given for educational institutions. So, and they said pursuant to a scheme framed by the government. So my question, I even got an RTI reply that government has framed no scheme. We used it, and still the court said, no, that act is a scheme. How can it be? It has to be a scheme under the code, you understanding? It can't be some other law which is brought. And the third point is about pricing. Mamre, you got that?
Yes.
Pricing.
So when the projects are coming in Goa, for example, Melauli IT, now Mirabag is going on, Chimber is going on, now Thivi, why are people objecting?
See, I tell you the biggest problem which the government has. They don't take people into confidence. If people were taken into confidence and told that we are going to come out with this project, you would probably know the mental state of people, the readiness to accept it, if there are some objections which the stakeholders or maybe those objectors have, maybe sometimes genuine, may sometimes be concerns, may sometimes not be genuine, whatever it is, the government can immediately respond and tell that these are your fears, but this is how we think of attending to it. And I think people, I am not saying everyone, but let us say a large number could be satisfied. Everyone can't be satisfied, let us be honest about it, but a large number could be satisfied, because it's everything, if there is a dialogue, proper dialogue, things will work out. And I think people will accept. But everything is being pushed by the back door, suddenly you get a notification, suddenly they put barricades, then people get worried, because they realize that with this change, not only the zoning changes, the topography changes, but also demography changes, and the entire village will end up becoming a city or something different. This is the fear what you find. Now as far as this, I think it's in Savarde or Sangay that this is going on. Their fear is of the water barrage which is being put over there, because today there is already a problem about water scarcity. Probably if the government had explained it properly, how they propose to do, how they are doing it, I think the situation will be different. Today you see what another thing which you have not asked me about is the sudden spike of electricity bills.
Yes.
Have we been told? But it's now being portrayed that it was approved by the JREC since October, and that's why I've been asking people who have been asking me about this, since when have you been getting high bills? You understanding? And I think that's a fraud. I think we'll have to get that sorted out. People will have to agitate, because otherwise your bills are already going to become double. And the worst which is going to come will be when the smart meter comes. When the smart meter comes, they may give all technical reasons why they would love it and why it should be there and why it will be good. But one thing for a common man, he is not going to see this mathematics, and he is not going to see graphs like how you see what you call this, your heart, this thing, what they call those
Cardiogram.
ECGs, you know, those ECGs. You are not going to look at that and see how your electricity usage is being spiked or not spiked. The question is, what is the burden on my pocket is what a common man is going to see. Vadlo or vadlo na muge bill. That is what at the end people are going to look. And trust me, under smart meter, you pay and you get your electricity. You have no money, you remain in darkness. So, you understanding? This is what I am telling you.
Electricity, now they are giving the new argument, new this clarification. Just few days back, just when I inquired, they said, तुमचे घरा फोन नाही हा, तर तुम्ही AC घातल्या, water heater घातला, or gadgets put up in your house. So you should change it accordingly. But that changes are not there, and these fines are imposed on the room.
No, that
Load
These are the clarifications.
no, that is one thing what we had this in Pomurpa when we had a grievance meeting. That was one of the justifications given by saying that your load has been increased without seeking permission by adding ACs, fridges and all this kind of thing. So when your load increases and your usage increases, you are being then put a penalty at the bottom. But the manner of billing has been changed. I will explain that little in detail, because those technical words I am not an expert. I will have to read those words and tell you all how it is. I will give you a separate disc on it. So that is one part of it. If tomorrow, and I advise people also, check if you are getting that penalty part, go for load increase. But load increase has nothing to do with smart meter. Please don't confuse one with the other. Smart meter is totally different. In a smart meter, you know the fluctuations of how you are using, which means when you are not using, your voltage is low. You can probably monitor it even electronically. Even on a mobile you can know what's your usage, which means when you are not at home, you're bound to have less usage. And so when the whole family is there in the evening or maybe in the night, there will be a higher usage. What conversely I look at it is, if there's a low usage and I can see, if somebody accesses my bill, a thief will also know where there is nobody in the house. Do you understanding how it works? He will know this is the pattern that nobody is here at this time. I will rob this house at this time. Do you understand what I am trying to tell you? It is not free from this thing. You may say everything, but we already know of people hacking into your system, people hacking into your this thing. This will crash, and finally at the end of the day we will suffer. Common man will suffer. This is what I am trying to tell you. It's not, some people can afford. About the letter of intent. Letter of intent, because under the law at that time, that's why I made an allegation on the floor of the House that you are bringing this amendment for the private university, if you remember it. Yeah, and I specifically said for MIT, because Pramod Sawant was amending so as to allow them to fit it, because they didn't have this. You understanding? And even the law was changed to allow them to have it on lease, even not in possession. Even after second time, I'll tell you there are two parts of it you must remember. First time they got a letter of intent when they never owned the land. The second time they got, before the amendment was brought, they applied for lease. Before they got the lease, they got another letter of intent, second one. See this, both times it was a fraud.